We'll go ahead and start if everyone's ready. Things are a little tight here, but we're kind of settled. I want to welcome you this evening. Thanks for coming out to this process meeting. My name is Patrick Riley. I serve as the manager of the Solid Waste and Sustainability Unit at DEQ, the Department of Environmental Quality, Land Protection Division. The purpose of the meeting tonight is to explain the steps of DEQ's permitting process that relates to the Tier 3 application for a solid waste processing facility that was submitted by Sooner Solid Solutions, LLC. I'm going to read to you something that was in their public notice of filing, just to get everybody acquainted with what's being proposed, what they've asked for, in case you're not familiar. So let me read this. Activities to be regulated. If the application is approved, they were asking to construct, operate, maintain, and close a processing facility to accept and process approximately 100 to 150 tons daily of non-hazardous industrial waste. Non-hazardous industrial waste will be treated through a stabilization and solidification method. Waste will be dumped inside concrete-lined pits where it will be mixed to initiate a stabilization and solidification process. And the primary function of the facility is to produce an alternative method for the disposal of spent caustic waste streams. And once the materials are processed and solidified, they'll be used to solidify and or amend oil and gas waste that then will be disposed of at an Oklahoma Corporation Commission permitted facility unless another method is approved by DEQ. So that's what they have submitted and asked a permit for from the agency that I work for, Department of Environmental Quality. This process meeting is held in accordance with Oklahoma Uniform Environmental Permitting Act, found in Title 27A, Section 214 of the Oklahoma statutes. So if you want to look that up, you can read. It's a prescribed process. For an application like this, we offer the opportunity for people to request a meeting to learn about how things are permitted. And that's why we're here tonight. With me from DEQ are Hillary Young. She's the Chief Engineer of the Land Protection Division at DEQ. And Jeff Biddick is a professional engineer in the Solid Waste Permitting section at DEQ. Tyler Williams is also here this evening. He works for Envirotech Engineering and Consulting firm. He's here representing Sooner Solid Solutions. I want to make a point that this meeting tonight is not for protests. The purpose of the meeting is to explain the steps of the permitting process and to let people know how they can participate in the process. My colleague Hillary will explain the permitting process. She'll explain when oral and written public comments can be made, how to request a public meeting in which you can comment on a draft permit if one is issued, and what an administrative hearing is and what opportunities exist to request a meeting. It's important to know, and I'd like to point this out, that the process that we're going through, the permitting process, is defined by Oklahoma law and administrative code. Right? That's the criteria that we use to determine if a permit is going to be issued or denied. It's not up to our individual opinions on the validity of a project or its merits. It is fully controlled by the law and the regulations. We know that you probably have a lot of questions about the project and what is being proposed. We're happy to answer what we can, but I want to point out that the permit application at DEQ right now is under technical review. So we haven't completed that technical review. So we don't know if it meets the laws and the regulations and the things that are required for a permit to be issued. So it would be premature for us to address any technical issues at this time. I want to point out that if you want to be notified of actions that DEQ has taken, if there's a permit that's issued or if the permit is denied, please make sure that you sign in on the sign-in sheet at the podium here and provide your email address or a mailing address so that we can reach you with that notification. Okay, so any questions about anything I've said so far? All right.
on your review?
Yep.
How much longer?
We anticipate having a response to the applicant soon. I can't say exactly when. We want to be very careful about what we do. It goes through a series of reviews. The permit engineers will look at it. It goes through the chief engineer and other management at DEQ before a response goes out. It's typical for an application like this to go through an iterative process so that there won't necessarily be a issuance or denial right away. It'll be a request for additional information or request for clarification. So it can still be a while before there's either a draft permit issued or a denial.
I have a question. Do you make field trips to the actual location?
We will before a permit is issued or a draft permit. We drove by the site today, as a matter of fact, just to kind of get an eye on where it is, what the surrounding land looks like. It's always we consider it a best practice before we would issue a permit for any activity to see the actual land in which it's going to happen.
Why is this targeted for this area? Why is the applicant, and I mean, why here in Hennessey?
Mm-hmm. That I can't speak to right now. I don't have an answer for that. Are you ready to talk about the permitting process? Okay. Let's get the.
No, just leave it there and stand behind it. Yeah, you're good.
We're going to get the. Hillary has a chart that shows the steps in the permitting process from start to finish. So she's going to show that and walk through those steps on the screen. And we may have to play around with it a little bit to make it.
Shut the lights.
Yeah.
Can you shut more? Do they have to all go off? Or
I think it's all.
Okay. All right. Great. Okay, so we'll zoom in when we want to start going through each piece of the process. I wanted to show the entire table so that you can get an idea of where we are in the process. It's the highlighted area, so there's still a lot of process left to go. Okay, so if you want to go ahead and start at the top and maybe too zoomed in. Okay. So, like Patrick was saying, our permitting process is governed by the Oklahoma Uniform Environmental Permitting Act, which is found in Oklahoma statutes at 214-101, Title 27A, 214-101 is where they start. And also, the administrative rules for DEQ are found in Chapter 4. And you can find links to both of those on our website. If you go to oklahoma.gov/DEQ, and at the top you'll see rules and regulations. If you click on that tab, there's a paragraph in the top part. You can click and go to the statutes, and then there's a whole listing of all of our regulatory requirements there for all of our divisions. And for those of you who may not know how DEQ is kind of structured, so we have 3 main media divisions, which are air, water, and land. And so air, as you would imagine, permits air emissions, water, stormwater, drinking water treatment, wastewater treatment, things like that, and then land protection, which handles the solid waste permitting. So this Uniform Permitting Act governs all of DEQ, and then some programs that have federal requirements would have additional requirements, but the solid waste program does not have additional federal requirements. So it's just the Oklahoma Uniform Permitting Act. So the first step is an applicant files an application with DEQ, and this application was filed in August of last year, and they are required to file or publish a notice of filing, which alerts the public that this application has been filed, and it's supposed to be published in a newspaper that's local to the site. And sometimes, when we're going rural areas, a lot of rural newspapers have closed, and it might be in the town over in their newspaper, but it just has to be a newspaper that's local and closed, and that everybody hopefully is reading. And for a Tier 3, which I failed to mention when talking about the Uniform Permitting Act, is that it's divided into 3 tiers. So there's tier 1, which is no public participation. Tier 3 is the highest level of public participation, and this is a tier 3. So for a tier 3, the notice of filing provides a 30-day opportunity to request a process meeting, and DEQ will hold the meeting if requested and sufficient interest is shown. And so we received requests for a process meeting, and the notice is given of the date, time, and place for the process meeting. And I think notice was published 3 times because 2 times it got the year wrong, because we're kind of pretty common problem, when you go from December to January to keep saying last year. So third time was the charm. And this is the process meeting. And so this is, where we're at here is the process meeting. These next 2 steps are things that happen at the same time the first 3 things are happening. So while all of this is going on, DEQ is conducting an administrative completeness review of the application. So what that means is that DEQ looks at an application when it comes in and determines whether or not it has enough information in it so that we can conduct a proper technical review. And if it's administratively incomplete, then we would issue an NOD and ask, to provide all of the information. It doesn't mean that the information provided in the application is technically adequate. It just means it's there. So this application was found to be administratively complete in October. Was it October 1st?
Around that time.
Yeah.
That sounds right.
And maybe it was October 9th. Of 2025. So it's been deemed to be administratively complete, and now we're in technical review. So DEQ reviews the application for technical compliance and requests the applicants to cure any deficiency. So what that means is we'll go through the application and look at our rules and our statutes and make a determination on whether or not it's in compliance with our rules and statutes. And oftentimes when we do technical reviews, we'll have what's called a notice of deficiency if there are questions or we need more information. So if we issue a notice of deficiency, that's generally just what we're asking for. We need more information so that we can do a complete technical review. I'm sorry, y'all. Okay. So once we've determined an application is technically complete, we will make a decision whether to issue a draft permit or a draft denial. So DEQ prepares this once the application has completed its technical review. And then public notice of draft permit or draft denial is published in a newspaper, and it gives a 30-day opportunity for people to comment, to submit public comments. So this is where you would have an opportunity to submit comments on the application, on any draft permit that might be issued, and also the opportunity to request a public meeting. So, and that's even if we issue a draft permit or a denial, it's published for public comment and a request for a public meeting. Now, alternatively, the applicant can schedule the public meeting when they do the notice of draft permit. Now, obviously, draft denial, that's probably not going to, DEQ publishes the notice of draft denial. So, but if you sign up on the sign-in sheet, that's why it's important to sign on the sign-in sheet, and we have your contact information, we will send you a direct notification if it goes to draft permit and the opening of the public comment period. So the public comments period is open, and you can mail public comments or you can submit public comments through our website. And the same thing for requesting a public meeting. So you can send in a comment, request a public meeting. So if a public meeting is requested, then we have we provide notice of the date, time, and place. It's published in the paper again, and it has to be at least 30 days prior to the scheduling of the public meeting. So there would be a 30-day window there, and that's required by statute. So, and the public meeting to accept comments is much more formal than this setting. We have a court reporter, which takes a transcript. We have people come up and give their comments. The applicant's there to answer questions, and we answer as many questions as we can. And And once that meeting, oh, I'd like to add too that if there's a public meeting requested, then the public comment period will extend to the end of the public meeting. So, after we receive comments, then DEQ will review and respond to public comments. So we would, any written comments, and then we would have to wait for the transcript to come back from the court reporter, and we review that and pull the comments out of there and respond to those as well in a formal written response to public comments. So again, once we do this written response to public comments, if it goes to proposed permit, and we will look at comments and what people are saying in their comments and take in consideration on whether there needs to be any changes to the permit. And if so, then we could make those changes to the proposed permit. If the changes were substantive, then we would republish. We want to republish and redo the comment period. So once it goes to proposed permit and the public comments are issued, we would send a direct notification, because again, there has to be a publication in the newspaper that opens up a 20-day opportunity to review the permit, the response to comments, and request an administrative hearing. So an administrative hearing is a quasi-judicial proceeding conducted by an administrative law judge, and the applicant and the requester must participate in the hearing as a party. If we get multiple requests for an administrative hearing, it would be combined into one hearing. And of course, you can have legal representation for that as well. DEQ has 60 days to, once, if an administrative hearing is requested, has 60 days to schedule a pre-hearing conference. And then during that pre-hearing conference, it takes place with the administrative law judge, the applicant, the requesters, and then the administrative hearing is scheduled. And each participant would provide evidence as to why they think the permit shouldn't be issued, if it should be modified or whatever, and they would present that to the administrative law judge, who would make a recommendation to the executive director of DEQ, and then would make a final decision. And then if that, at the end of all of that, DEQ's final decision would be made, and then a notice of final decision is where DEQ provides public notice of final issuance or denial. So that is our process. Does anybody have any questions on the process?
So the law judge makes the decision?
What the administrative law judge would do is, oh, I'm sorry.
Okay.
What the administrative
I'm sorry.
what the administrative law judge would do is
Yeah.
make a recommendation to the executive director. And once it hits the administrative hearing, it goes to our lawyers. The lawyers kind of handle it after that.
Okay, and then there's just one person at the top that makes that decision, is that what you're saying, and not a committee or what?
You're right. The administrative law judge makes a recommendation to the executive director of DEQ, who would make a final decision.
Who is that?
The executive director, it's Rob Singletary.
Say again, please.
Rob Singletary.
Rob Singleton.
Mhm.
I have a question. You made a comment that the notice goes to a local paper close to the site. We don't have a local newspaper in town. We have one in Kingfisher,
Right.
20 miles away. We have one in Enid. There's one in Oklahoma City. Do they have the ability to go to Oklahoma City and publish that where nobody in Hennessey is going to see it? Does it have to be in Kingfisher paper?
Yeah, it would need to be. It wouldn't. We wouldn't. Oklahoma City would be too far. Yeah, we would.
Well, I live just across, because this property's not too far from the county line. I live in Garfield County, so, I think it needs to be in Kingfisher County and Garfield County, publish both.
Well, the statute requires one paper local to the site. So,
Okay,
but as I said,
right.
I will send, or
Yeah,
we
I mean,
will
I'm
send direct
signed up so now we
notifications.
know.
Yeah.
And you guys, just to make clear, you don't, right now, if there's any questions, you had said it was gonna be a cement line pit. You don't have the particulars on that. That's for the next meeting, correct?
Yes.
Okay, cause some people say a cement pit and then they use what they call soil cement for ground stabilization, and it's a whole different deal. And one other question, I don't know if you'd answer me this. There was a mud disposal that's made to paper in Garfield County up by Hillsdale that's owned by Nemaha. Did the DEQ have anything to do with all the stuff that was coming in there? Originally, it was an oil and gas for mud, for water-based mud, and then they took it over, and there got to be a lot of stuff going in up there that, you know, I didn't know if y'all were involved in any of that.
If it's an Oklahoma Corporation Commission site, then Oklahoma Corporation Commission has jurisdiction.
Okay, well, I didn't know because there's just, on that particular deal, there's been so much brought in from so many places, it almost sounds like it's a loophole between DEQ and between OCC, and I was just curious, you know, if there would be the same, or what we needed to do to make sure that the same loophole, if this gets permitted, you know, because that disposal's been open since the mid-'80s, and there was never no trouble till about 4 years ago.
And they done away with it.
No, well, they finally just got it shut, but there's a lot of stuff. I mean, you know, I'm in the oil and gas industry, but I mean, we were up there cleaning up spills and stuff from some of the other stuff, and you know, I got some friends that live up there, and I just wanted to make sure what was being brought in there, you know, because what the Enid paper says, nobody can really tell you who's responsible for it, because you know, it was getting where, you know, it's burning people's eyes from 3 miles away. You know, I mean,
Is this something that you guys would monitor?
Yeah, if it were permitted as a solid waste processing facility, we conduct regular inspections.
Regularly, biannually, or?
It's quarterly, isn't it?
Quarterly?
Yeah.
Yeah. I mean, and more
And then-
often if necessary.
Yeah, and that's, we have a complaint process. So you can call in a complaint, you can file a complaint through our website, you can do it anonymously. If you do it anonymously, you won't be kept in the loop on how it's resolved because we won't know who you are. But, you know, so I would recommend that, you know, if you have a complaint, then you call in the complaint system.
We'll clarify the 3 mile radius.
Well, there's a question, let's step back. Do you have a limit of how close it can be to a town city limit? OCC has a 3 mile limit where a site like this cannot be, the rule says will not be established within 3 miles of a city limit. Does DEQ have anything like that?
And this side of 2.3.
Yeah.
I don't think we have that.
No. There are certain location restrictions specified in the solid waste rules, but proximity to a town or municipality is not one of the limits.
Proximity to seismic activity?
There are some for, depending on the type of facility, there are some regulations that apply to seismic activity and fault zones and things like that. And that would be part of the technical review. So, you know, part of the process in reviewing the permit application is to compare it to all the restrictions that are in the solid waste regs to determine if they meet the proper location criteria.
What about over aquifers? Because we got the cities, I'm rural, I live out in the country, I got on my own well. We have the city of Hennessy's water comes from south of town. I don't know how much it drifts up to the north, but there's concerns of what could leak because my well's only 40 foot deep. They're digging 25 foot down. You know, that's not very far for it to leach into the water system.
Right, and that's a technical issue, and then we would look at that. There are criteria for storing waste, for liner criteria for storing waste. There are certain regulations pertaining to separation from groundwater if it's a waste disposal facility. So depending on the type of facility, what's being proposed, all that will come out in the technical review to make sure it's compliant with any appropriate regulations.
I have a question. Could you explain to the folks here this evening, as part of your administrative review process, this is the type of permit that would fall in the category of a may issue permit, or would it fall in the category of a shall issue permit?
I mean, we review permit applications as they come in to determine whether they're in compliance with our.
I'm sorry.
We review applications as they come in to determine whether or not they're in compliance with our rules and regulations. And applications that are in compliance with our rules and regulations, then we have to issue a permit. If they're in compliance with our rules and regulations, they meet citing criteria. So.
I'm going back to kind of his comment on the air, water, and ground soil. Do you do testing beforehand of that site or neighborhood sites? I live downstream, down air, down whatever you wanna call it, from this. If I have a water problem, a soil runoff problem that looks funky, or I have something odd come up, is that something that I make a complaint to you? How do you handle if something goes wrong in the future? What are your standards? How do you handle that? Can you explain it? I know the environment tech guys here. What do you do if my water, this goes in and we have a huge deluge of rain and something overflows or gets in the system? What do you do?
Well, it's gonna depend on what the problem is. Because.
I know, I get that. I wanna hear them explain to me.
It would depend, if there were an issue, it's gonna depend on what the issue is, on how we would address it. If they're not in compliance with the rules and regulations, we have, processes in place for enforcement, and we would do that. If there were issues with having caused some kind of environmental problem, we would require them to address it. So, it's kind of a broad issue, like if something can go wrong, then how we address it? Well, it's gonna depend. It's gonna be case by case, it depends on what the issue is. But, we do regular inspections, and if we see issues or if something is reported, facilities are supposed to self-report if there's an issue as well. Then we would go out and look at it, and we make a determination on whether or not, there needs to be enforcement action, or whether or not there needs to be some sort of activity to address it, whether it's if they cause some kind of problem that needs remediation or something like that. So yes, we would require steps to address any kind of issue that was produced by any facility that we regulate. So.
If there was an issue, do they just get a slap on the hands, or is there a monetary fine daily?
It could involve a number of enforcement actions. There are a number of tools available to DEQ to enforce and ensure compliance. So, and it depends on the severity of the incident. It depends on repetitive nature. It depends on potential environmental impact and impact to human health. So all those things will go into factoring what the enforcement action might be. But yeah, there are things in the regs that specify, for instance, a dollar amount, penalty per day, per violation, that kind of thing. Typically, our goal is for facilities to be in compliance and to gain compliance. If something happens and they're, for whatever reason, aren't following the regs as they should, and we become aware of it, our goal is to get them back into compliance as quickly as possible. And we try to do that cooperatively when possible, and if not, then we have other tools that we can use.
It's too late then. It's too late.
Exactly.
Your water's already messed up forever.
Yeah, and one of the things, and I heard your question about soil, air, and water and those things, and what if something goes wrong. Our goal is the regulations are written contemplating how facilities will operate. And it's our hope that the regulations are structured in a way that requires facilities to have plans in place, have engineering controls in place before they ever begin, that help ensure that their operation does not jeopardize human health and the environment. I mean, the mission of DEQ is to protect human health and the environment, and so we want to do that. So part of the technical review is to make sure that they have sufficient plans in place, that there are sufficient controls established, and that we write conditions for operation that are such that will minimize potential for any impact on the surrounding area. And that's in everybody's best interest. That's what DEQ wants, that's what you want, that's what the facility operators want. So that's all part of it all goes into the technical review.
Are there facilities like this already in Oklahoma?
I'm not familiar with a facility that's just like this.
So this might be one of the first ones?
Well, we have other solid waste processing facilities, they're all a little bit different, but I think this is the one for this. I don't know that we have one that's.
If I wanted to find those other facilities through an open records request, specifically, what should I ask for? Find information that the DEQ may have.
Do we have those on the website?
I don't know if they're identified on the website as solid waste processing facilities. You could look for solid waste processing facilities. That's a key word.
No question. In your technical review, do you go on what the people want or is it just completely the ground? Because this is right across the road from my house, like 100 feet from my house.
Right. So we follow the regulations that are provided. The rules that govern solid waste permits are in Oklahoma Administrative Code 252.515. It's a whole set of regulations that contemplate everything from location restrictions to operating criteria to engineering controls. So that's what we use to evaluate things. Apart from location restrictions that we talked about as far as like proximity to municipalities, we do not have limits on how close a facility can be to a neighboring home, say.
Why not?
That is
And
not good.
how do we get that changed?
Yes.
How can we
Right,
get that
I have a
changed?
4-year-old daughter that lives on down that road.
Do you have any idea what this smells like?
I don't want to smell.
And we're
So-
taxpayers too. We don't want it.
Right.
And if you don't have a facility exact like this one, this is a pretty big gamble to people's livelihood, children walking down the road. And you can have all the policies in place, but if you've never been down this road, once again, that's a pretty big risk, I feel like.
But that'll all be considered in the protest part of it, right? I mean, if we wanna protest because we live across the street from
I'm
it.
hoping it gets denied.
No, I know that, but God forbid
Yeah.
it doesn't.
I know.
I mean,
So I
there
have a
will still
question.
be a process to protest this.
There is the opportunity for an administrative hearing at the end of.
How much weight does a protest have? I mean, if someone has, like her, has her house 100 feet from this thing and she protests it, is it blown off because there's a rule, there's no rule? Or how does that work?
Protesting and done deal.
I mean, so there are a couple things. When we do our technical review, and I mentioned this before, that it's not up to us, it's not up to our opinion as to whether something gets permitted on its merits or its lack of merits, that kind of thing. So we'll look at the rules and regulations, and that's how we decide if a draft permit is issued. If there are comments in a permit meeting that we have, public comments, for instance, if the comment is it's too close to my home, then we will look for a regulation that limits how close it can be to a home. And if there's not a regulation that says that, we will state that in our response. Now, if then it goes beyond that stage from the draft permit to a proposed permit and an administrative hearing is requested, the bar to have an administrative hearing is that there's a demonstrable environmental concern. So if there is a party that is a stakeholder in the project and they request an administrative hearing and claim in a demonstrable environmental concern, then you start the administrative hearing process. And again, like Hillary explained, it goes to an administrative law judge, and that's where the case is made for potential harm or not versus the merits of the project. That's where both sides get to express their concerns and are heard in a formal setting before the administrative law judge, who then takes in all that into consideration. And then again, that kind of leaves then the engineering and technical realm that we're used to and goes into the legal arena. And that's not really something that, since we're not attorneys, we don't I can't speak with a whole lot of confidence about that, but that's how the process would work.
This administrative law judge, he's DEQ, or is he public judge?
I think he does everything for DEQ though.
I'm not sure about that, and I think there may be more than one.
Do they have 24/7 monitor?
As far monitoring of the facility,
Yes.
any monitoring that would be required will be part of the technical review.
Wouldn't that be required?
I don't know at this point. It depends on what's being proposed and what the review determines.
Who's in charge of you guys' regulations? I mean, who writes you guys' rules?
Yeah, that's a good question, and I heard a comment on how do we change rules if we don't think the rules are efficient, how do we change that? So there's a process, like any bureaucratic process. It's long, it's complicated, but we have a public body that reviews all solid waste regulations. It's called the Solid Waste Management Advisory Council. It's made up of 10 members that are appointed from different areas of expertise representing different stakeholder perspectives. Like there's the field of geology, the field of engineering. There's a position set aside for an elected political official. There's a slot specified for somebody from an environmental group. And they review any rules that DEQ would propose. Like, for instance, if I have a rule that I think, okay, we need a rule that specifies how a landfill liner should be built. Then I have to present that rule in a public meeting to the council and these experts representing these fields, and they make recommendations whether or not it's a good rule or whether or not it should not be proposed. So then at that point, if they approve it, it goes to the next phase, which is the Environmental Quality Board, which is made up kind of a similar way, but they look at all the rules, not just solid waste. They look at air, land, water, and they make recommendations. Yes, this was a good idea, or no, it's not. And then if they approve it, it goes to the state legislature, who can then approve or not, and ultimately it's up to the governor to sign it. So rulemaking takes a long time, a year or more at least, to make it through that whole process.
And I'd like to add too that
We don't have a year.
the rules come from the Solid Waste the Solid Waste Management Act, which is a statute. When you go through that, you'll see where it says that the statute has said the Environmental Quality Board shall promulgate rules for landfills. And in some areas, it gets really specific about some things, and in other areas, it's more generals. And that's how we promulgate the rules. It starts with the statute, which is passed by the legislature, and then we will promulgate rules based on statutory requirements.
But any citizen, sorry.
That goes through and then once we promulgate rules, it goes through the process which Patrick just described for rulemaking. You can petition for rulemaking as well.
Yep. So any citizen can petition for a change in rules. And if there is a rule that you don't think is adequate, or a rule that you would like to see that isn't in place, then you can petition that to be presented in front of the Solid Waste Management Advisory Council.
How do we get that process started?
There is one of the rules that Hillary talked about, Chapter 4 rules on our website, is the Chapter 4, OIC 252-4, and there is, in one of the appendices, there is a form that you can fill out and describe what you want, and then it tells you what to do. Send it to DEQ, and then they'll.
Yeah, it's laid out in our Chapter 4 administrative rules.
Okay, you talk about all these chapters and rules and this and that and numbers. Where the heck is all that?
Right.
For just the common person.
No, I know. Yeah. I get it. I get it.
Yeah.
It's accessible on our website.
I can speak to that.
Yep.
If anyone wants to look at that on their own, there's a website called OSCN, Oklahoma State Courts Network, and all the state statutes are on there. I would submit to you that I've read these solid waste regulations, and it's not the most engaging reading. However, I advise each of you who are concerned to do so. They're relatively easy to find. I believe Chapter 27A, is that right?
Yeah, all of that.
I know how to find it, but I can't remember.
Title 27A is
Title
where
27A. Additionally, in order to find any, not just the DEQ regulations, what you would do is go to the website for the Oklahoma Secretary of State's office, and there's a link you can click for the administrative rules. Off the top of my head, I don't remember what title the DEQ rules are in, but again, it's organized very well, the table format. Again, I submit I've read those rules as well. You will find the reading very engaging, however, I encourage you to do it.
What was the name of that first thing, OSCN?
OSCN.
OSCN.net.
I think it's .net.
It's .net, yeah. OSCN.net, yeah.
Could you put that out?
This question may not be directed at DEQ as much as it is at the operators. Why was this site chosen rather than going out farther west where it was less inhabited?
One of the owners owns the land.
Yeah, I can't answer that question. I don't know that we want to get into that now. If it might be a question to ask during the draft permit process, if it makes it to a draft permit. But yeah, again, the specifics of the application and the project, we're not prepared to talk about right now. Ma'am, you had a question.
As tenuous as the water situation is, not only in the rural environment as well as in town, why is there not a statute describing how close this can be to a town because of the water?
Now, there are regulations that talk about the proximity to wellhead protection areas, to some water zones. And I think that's part of the technical review. That proximity specifically to towns, there is not.
Would it be helpful if we supplied you the depth of our water wells? This gentleman's at 40 feet, mine's at 25, I'm catty-cornered from this place.
Mm-hmm.
I have one across the road too.
And we're, it's 25 foot deep on these pits, man, that's just right there where my well's at.
So when the public comment period is open, that would be a time to make that comment.
Fresh water, it's critical to the people, to the livestock.
Ponds?
I think there are a lot of the farmers and everything around there that the older like wells are no deeper than 20 or 25 feet.
Right.
Mm-hmm. Okay, that would be a good comment to make.
So I just wanted to say for everybody that was writing down the statute for the Solid Waste Management Act, it's titled 27A, and it starts at 2-10-101.
What was that last part?
2-10-101. That's the start of it, and it goes on. I think the Uniform Permitting Act is a much easier read if you guys want to go through the Uniform Permitting Act.
Does the DEQ have the final say in this, or does the Corporation Commission come involved at what point?
So this permit application, what we do is just DEQ's jurisdiction. It does not involve the Corporation Commission.
Okay,
So-
but you had the final are you the final?
There's a separate permit application before the Oklahoma Corporation Commission to
Oh,
be
so we have to
located
do that.
adjacent to this facility.
I see, so which comes first? I mean.
That's a good question for these folks.
So.
We aren't involved in the Oklahoma Corporation Commission's permitting process.
I understand that, but
So
does DEQ come in first and then the Corporation Commission, or vice versa, or what? How does that work?
If DEQ doesn't approve the permit, can the corporation approve it?
They can't approve our permit.
No.
But-
Two separate permits.
That's up to
It's
the
two
Corporation
separate permits,
Commission.
but can they go ahead and permit him to go in and start doing
DEQ
construction?
denies it, can the OCC?
Can they
If
let
they
it go
have an
ahead and do it?
application before the Oklahoma Corporation Commission, the Oklahoma Corporation Commission will make the decision on that application.
On their part, but can they go ahead with just Oklahoma, or do they have to have DEQ permit as well? Do they have to have both permits,
Because
or can they get by with just one?
They're two different facilities,
They're
so
two
it's two different permits.
Right.
is what it's-
That's what I'm saying, but
Yeah,
can they,
but they
They're
can't answer
separate-
what those
we're
it's
separate-
different
right,
deals.
separate
They might get
jurisdictional.
one, might pass and one may not.
it doesn't die if you guys stop. If you
Their
guys
part,
deny the
theirs.
permit, it doesn't.
You
Yeah.
can't speak to that, to the viability of the project based on the outcome.
They can still do the other part.
So does the Oklahoma Corporation Commission look at your study and then
This is not covered.
decide?
I
mean,
think
you're
they're
doing the
independent
environmental
processes.
study.
I think they're independent processes, so they're describing different activities. So I can't speak to what OCC would look at or what decisions or what they would base their decisions on. But the activities that are permitted, DEQ would permit DEQ activities, and there are different things that OCC has jurisdiction over, oil and gas production waste, for instance, and disposal of those that we don't have jurisdiction over. So if they're proposing an activity related to that, that's strictly OCC, and DEQ would not be involved.
So they don't rely on your environmental study?
They wouldn't. I can't say what OCC would look at.
Yeah, we can't speak to OCC.
Would DEQ, if they denied it for some reason, would DEQ take that into consideration?
I think that what we are permitting is strictly managing waste that's under our jurisdiction, that's independent of an OCC related activity. We would not issue a permit that is predicated on the issuance of a permit from another facility. Another agency. Yeah, I'm sorry. Thank you.
I think I read somewhere that the intent was to commingle waste from each series of pits.
So,
and I think that's maybe what some of the folks in the room here tonight are asking is how would that work if they want to commingle waste?
All right, so we would write any permit that we would issue, we would write in a way that's independent from any necessary permit of OCC. So for instance, if I think in the notice of filing they talked about using taking the waste from the DEQ facility and taking it to a OCC facility and mixing it with waste. What our permit would say is you can process this waste that's under DEQ's jurisdiction, and then once you finish that, you have to dispose of it in a way that DEQ would allow. So we wouldn't say take it to an OCC facility. We would say dispose of it in a facility that's permitted to accept it. So if it's a facility if the waste has to go to a disposal facility like a landfill, then that's what they would have to do. But we wouldn't say you have to get an OCC permit or it has to be in an OCC permit. So anything that we do will be independent of Corporation Commission.
How do we interject ourselves into this second permit?
I'm already working on it.
Okay.
I have a question.
Go ahead.
So in this permitting process, does the DEQ take into account where the source of this waste material is coming from? Meaning from out of state or in state? Does that make any difference in your permitting process?
So we do have regulations that apply to the volume of waste that would come from out of state. And I'm going off of memory, but if I think the regulations say if a facility is going to receive more than 200 tons a day from out of state, they have to have an approved out of state disposal plan. And then that requires a provision of information to ensure that we are not getting hazardous waste from out of state. We would not restrict waste coming into the state. I mean, there are certain laws on interstate commerce that we can't restrict, but we do want to make sure that any waste that does come from out of state is safe to accept in any facility that we permit in Oklahoma.
So how do you know if the type of stuff that they're bringing in once you have a permit?
We have a regulatory requirement that for generators that generate more than 10 cubic yards in a month, they have to fill out a what we call a non-hazardous industrial waste certification. So they're certifying that the waste that they're sending to an Oklahoma solid waste disposal facility is not hazardous. And they would have to do that either through knowledge of process or through analyticals. And that has to be submitted to DEQ.
So they have to fill that out. You don't monitor that. There's nobody to monitor that other than the company filling that out themselves. So they could basically.
The generator would fill it out. The generator would fill it out,
which is the company.
It's the generator of the waste, not the
receiving
facility that's responsible for
so
that.
It's not tested.
I mean, and it's for hazardous, I mean, it's to certify that it's not hazardous. And, you know, generators, you know, typically don't want to certify something as not hazardous if it's hazardous, because you can get a lot of trouble for that. I mean, there's huge fines, there's lots of regulations surrounding hazardous waste as far as transportation and manifesting and things like that. It gets really complicated.
So how does DEQ classify spent caustic? Because that's what they're going to bring in by rail to Kingfisher County.
Well, spent caustic from petroleum refineries is typically a hazardous waste.
Okay.
And so the generators of that are sending it to this facility, because the facility says they will not be accepting any hazardous waste, will have to certify that this is not a hazardous waste that they're sending to the facility. And then
Who monitors it?
If spent caustic is considered hazardous, how can they bring it in?
well, it's a characteristic hazardous waste. So oftentimes when you have, there's listed hazardous waste and there's characteristic hazardous waste. And so oftentimes, sometimes when you have characteristic hazardous waste, you may have a waste stream that doesn't quite meet the characteristic. So for an aqueous waste like a spent caustic, it's a pH of 12.5 or higher would be considered hazardous. So anything under 12.5, and then anything 2 or less
That's
is
why
also
on
hazardous.
the application, they say, what, 9.9 or something like that? It's all,
So,
Yeah.
so by the generator, if this is coming from Pennsylvania and Ohio, whoever's generating that in Pennsylvania and Ohio has to certify this process you've been talking about.
They would, if they're sending more than 10 cubic yards in a month, then they would need to
And
fill out the
report it
NHIW.
to who?
The NHIW certification is sent to DEQ.
Meaning you?
Yeah, the solid waste group, yeah, solid waste compliance, I think looks at it. Because we have a solid waste permitting group and a solid waste complying group. They're separate groups, they work together on a variety of facilities that we permit. So our compliance group looks at the NHIW certifications.
Does DEQ take into consideration bringing this hazardous waste through communities and stuff en route to this facility? Is that part of your process?
Well, they are not, this would be a solid waste facility, so they cannot bring hazardous waste into the facility. So,
Are they gonna be able to expand this facility if it's built without any other regulations or anything?
well, that's where, you know, our chapter 4 rules could be helpful. When I talked about the tier rules, it lays out in chapter 4 what type of permitting action is what tier. So minor modifications of permits are tier 1. Tier 1 doesn't require any kind of public participation. And then tier 2 tier 2 doesn't have an administrative hearing. So it has less of a process than the tier 3. So it doesn't have an administrative hearing and it doesn't have a process meeting. But it does have like a draft permit and a public comment period. So
Does every load there, does it have to be certified, have a bill of lading or something to trace it back to where it comes from?
So, I mean, as far as someone sending large amounts of anything, if it's industrial
Every
waste,
load.
it would, I think typically with our NHIW certifications, they test the process when a generator is sending something to a solid waste facility. And if they send in analytics, as long as that process doesn't change, then we typically will accept that. If there's a change in the process, the generator needs to change. And generators are if you're talking about petroleum refineries, they're typically pretty knowledgeable about waste streams and things like that. So, and generators do not want to get in trouble for shipping hazardous waste, So that's that, and one of the things for the NHIW certification is to ensure that we don't have hazardous waste accidentally end up at a solid waste facility where you have a issue where the facility has to reject it and then it's got to be shipped back and that type of thing. So, and that's for all the facilities that we permit.
I have a question. I just want to clarify. I'm not sure everyone in this room understands what you mean by hazardous waste. I think I understand. I'm not sure, but I think what you're saying is the term hazardous waste is a legal term defined by statute or by regulation, but that doesn't mean that just because this waste would be classified as non-hazardous, that it couldn't still adversely affect, say, somebody's water well or something like that. Is that fair to say?
I think that's fair.
And you would allow that to happen? By your rules?
Well, no, our rules are designed to not let that happen, so.
Okay, so why is it even being considered? in
When
an
somebody
area
files
like
an
this?
application with DEQ, we're required to consider it. I mean,
But so that's where it comes into your technical
yes,
review?
yes.
And who are these people? What I guess education do they have? What qualifications do they have to review this? Do they know what the mixing, what the output, what it's going to emit, the mixing of this? Will they identify that? Are they educated enough to know what's gonna happen when these items are mixed?
So, go ahead.
We have a variety of experienced and credentialed environmental specialists and scientists and professional engineers that work at DEQ. We have geologists, people with expertise in geology. We have those that are experts in engineering. There are folks that work even outside of our division in the water quality division or in the lab that can provide expertise when necessary to make sure that we understand what's being proposed and processed. So one of the reasons why it takes so long, and I know you guys are anxious for a decision, but one of the reasons why it takes so long to complete a technical review is that we want to be very thorough and we want to document that we have completed a process and done all appropriate due diligence in our review so that when we do come to a decision, it's very defensible and that we're confident that what we have done is appropriate and satisfies the regulations and good engineering practice.
You are aware, there's been talk about DEQ permit and OCC permit. You're aware that this is all right next to each other on the same piece of land, right? I guess.
We are aware.
Yeah.
Okay, does that make any sway you one way or the other with your decisions? Is that a positive, a negative? Is it does it consider it any way at all?
Our regulations don't speak to that, to proximity to other facilities. So, so I would say no.
Okay.
And there was a question over here. I'm not sure we finished the answer to the question, but it was about what happens if they want to expand the facility. And Hillary was explaining the tiered process. And if at a certain point, if they wanted to expand beyond the boundary that they delineated in their application, if they said, okay, this is where we're going to put it, and it's going to go beyond that area and encompass more land, then that's a similar process to what we're doing right now. That would trigger the Tier 3 process. They have to file notice of application and go through all those steps.
But that is a possibility?
It's beyond our...
Yeah.
Well, at 150 tons a day, how long would it take them to fill up this facility? You know?
That's in the technical review, in the application itself, it may speak to how much capacity the facility has.
You don't know that?
My understanding is that there is not the waste will not reside at that facility. It doesn't stay there.
Yeah, it's going to be transferred to permanent storage pits, some of it. So why does DEQ not monitor the permanent storage pits of that waste that is being mixed in that application? You know, that the material that you're looking at is mixed in one pit, and then it gets transferred into other pits, and these are storage pits. Why does DEQ not need to issue a permit for that and monitor this, because this is permanent?
We'll address the technical issues in the with the application with our response.
Okay.
I have a question about the applicant or the person who owns the company that owns several other companies. Do you have any records, maybe this would be an open records question, but has that particular individual, has he been sanctioned by DEQ for any problems with any other permits that they may have? Or I say sanctioned and I'm not using the correct word, whatever would happen. That he's done anything wrong is what I'm asking, I guess.
Violations.
I don't have any information.
Violations, good.
I don't have any information about that, but one thing that in our regulations for a new applicant, there is a requirement to provide what's called a disclosure statement. And what the disclosure statement provides is a list of owners and officers in the company that that identifies who they are, and then it asks questions about any other permits that they may have held, environmental permits, and any questions like you ask if they've been if any violations or any criminal activity, say, has been noted. So that's part of the application process.
But do you verify that information, or you just take their word for it?
It's all part of the review.
Yeah. Thank you.
So what if the applicant is already violating? What if the applicant is already doing something that is in violation of DEQ rules and regulations? Do we contact DEQ and let you know?
So if you were, yes, if you were, for instance, if this facility were to become operational and you noticed activity that you deemed as threat to human health and the environment, something's not right, this doesn't look good to me, even if you're not sure, then our 1-800 complaints number, or it's also available online, is the number that you call. And someone fact check me. It's 1-800-522-0206.
And you can just go online and file.
And you can do it online.
But what I mean is, if he's doing it already, before he
I see.
even gets the permit, how will you know? Will you check, because he has.
You're talking
other
about
facilities,
another site?
Other sites, he does have other sites.
So review of the application, review of the disclosure statement form. I mean, we'll do our due diligence. I don't know how to answer that. At some point, it becomes a legal question about what is permissible as far as issuing a new permit to someone who has been identified as as having prior violations.
Along that same line, another question. What does it take for a citizen who is very suspicious that a process has been going on with contamination right now? What is that process for the citizen to get DEQ to evaluate and look at it?
And I would refer that to the complaints line. And Hillary mentioned too, there are ways to file a complaint. You can publicly, you can leave your name and let it be part of the public record. You can file a complaint confidentially, in which you provide your name, but you request that it not be disclosed. And you can also file a complaint in which you're completely anonymous. Under the first two scenarios, if you leave your name either publicly or request anonymity, then DEQ is required to follow up with you in a certain time, specified time, as to the results of what the investigation revealed.
How long is the response on that? If a complaint goes in, how long before they check it out?
Yeah.
Is it 48 hours? No.
I'm sorry,
Yeah.
along the same line. So there's no one that I can call and talk to.
Yes, you can call our 1-800 phone number at DEQ and talk with someone about that.
And who will I talk with?
There will be an environmental specialist. We have a division called the Environmental Complaints and Local Services Division. And we have regional offices around the state. We also have a presence at our headquarters in Oklahoma City. And their primary role is responding to complaints and investigating things. What happens a lot of times is a field inspector will go out, see what the nature of the complaint is. Is it illegal dumping? Is it surfacing sewage? Is it a violation at a permitted facility? And then they will refer the complaint to the appropriate division. They may talk to the Solid Waste Compliance Division. They may talk to Water Quality. And then refer it to someone who has more expertise on that particular issue and can appropriately respond.
And complaints, when they come in, they're logged into a complaint system and they're tracked. And I believe we have to have a response within 90 days, a final
final
A
response.
resolution.
So 90 days, they could.
A resolution within 90
They
days.
could do something and get rid of it in 90 days and it's still been.
A resolution within 90 days. So that would mean we would go out there in that timeline and take a look at it, and either within that 90 days, it would be referred to a media division, either air, land, or water, or it would be resolved at the ECLS, in the ECLS division.
And is that 800 number available 24/7, 7
Yes.
days a week? Someone is available to talk to on weekends and at all times?
Someone there is a phone that goes home with people.
Okay.
And the line is monitored. I can't say that it's answered 24 hours a day. If you leave a message, someone has that phone, and the intent is to respond during non-work hours and over the weekend.
Okay, thank you.
So if a person has a complaint, the agent or whoever is there will respond to that complaint. Am I correct?
Yes, if you
And they
file,
will come and do a field inspection.
they will investigate. They will investigate.
If you're the filing the complaint and you have witnessed
Yes.
the issue, that yes. But if you're hearing from people that things are going on and you haven't actually witnessed, whoever's witnessing it is the one who needs to call in the complaint.
Thank you.
So what if it's on private property that's not accessible, it says no trespassing, can DEQ just go on that property? Or would they have to contact the owner of the property?
My understanding is you have to have permission of the owner.
If there's a permit issue, it's a lot easier, because any permit that's issued, DEQ has authority to enter the property. For private properties, it's more difficult. Yes, sir.
I'll be backstepping a little bit. There's quite a bit of concern here about water quality. My place, it's 5 generations on this farm. It's 1.5 miles downstream. We've got a spring that goes across 2 of our farms right there. We've got 3 water wells, none of them are deeper than 20 feet. If something does spill and contaminate the water, I got dead cattle. How you gonna fix that? I mean, slap on their hand, fine some money, that's not gonna help me.
Yeah.
Right.
It's pretty nice.
What's the recourse? File a suit, they'll go bankrupt. So we're still stuck.
How long a process is this gonna be?
State of
Like, I know you
Oklahoma.
can't really tell, it's gonna take a year, where they could be doing anything, or is it gonna be 6 months, or with going through all this? How long could it take?
I mean, I would say, if it goes all the way, if we issue a draft permit and it goes all the way to administrative hearing, it'd take at least a year, at least.
And to Gary's question, that's what a lot of us here are concerned about.
Right.
So, how do I say this tactfully? But how could a project even be allowed to come to fruition, to be installed when there's this kind of danger? Okay, it's clear to us. It's not if something would happen. It will be when something happens. And we're talking all around a lot of things, but there's the spent caustic that we're talking about, the fly ash that is in this application. Those 2 items that will be mixed. Whether they're, regardless of how they're classified under the rules, I don't want to breathe in the fly ash, neither do you. I don't want any of that caustic in my water, on my soil. I don't want to smell it. I don't know what's in the fumes that I'm smelling. Well, I do, but and it's not good. So again, it comes to you through this in your technical review. I realize when things get put in front of you, you have to go through it. You have to give it, due notice. Do your due diligence. But where does the common sense, where does the morality come into play in the decision?
And will you listen to landowners' concerns? All of us? Well, I know there's a process, we can file
And that-
comments, but how do you weigh, the landowner's concerns against a business that wants to put this in to make money, that's all it is, to make money.
That's why I don't know why they take this whole review is taking so long. You should have been over and know we're not doing this to these people.
The people in the area are not only at risk, but those trucks that are on the road, they might encompass 1,000 miles from here that throw people at risk if there's an accident.
And I appreciate your questions. I hear what you're saying. What we have, and at times it feels limited, but all we have that we can work with are the rules and regulations. So you mentioned things like morality. There are no rules that talk about morality.
There's no morality is what you're saying.
I'm saying we have rules that talk about. We have
How about you individually?
No offense.
Sorry,
but no, I'm not taking. There are. I mean,
You can't legislate.
we look at engineering controls. We look at tons, miles from water wells. We look at all these things that are very physical, very concrete. Those other things that are less tangible are not figured into the engineering review of a permit decision.
Well, a lot of this stuff, when we're talking about the water, I mean, that's concrete. It's right there.
So what?
The 20-foot, 25-foot, 30-foot depth wells, that's not.
And those
it's concrete. It's right there.
And those are technical issues. If there are rules and regulations that apply to separation from groundwater or the depth of wells or proximity to wells, then that's something that we can look at and we'll take into review. If there aren't any rules about that, then we're limited in what we can do. We can't say that, you know what, this facility may cause a problem or there are concerns about this. If there isn't a rule, then we're limited in what we can say. Now, at the during the administrative hearing process, if there, that and the draft comment period, that's when you can make all the comments. And I can tell you that we will go through every comment that is issued, every statement that is made at any public meeting that may occur, and we will look at the transcript and we will write a written response, carefully considered in how that weighs into our decision. But you have to know that we are limited by rules and bylaws.
Well, I guess that's why I asked, where do we go to start the process?
Right.
Change it, yeah.
Right.
Do you have any idea where they're gonna access this facility or anything?
Facility access, roads, and entrances would be in the application.
Rumor has it some of those roads may kind of deteriorate. It'd be hard to get in and out of, but just a rumor.
Yes, ma'am.
This is technical, and you say it's all about technicalities. I have water board approved water wells, and I have cattle tank water wells that are, 20, 25 feet that are not water board approved, they're just my cattle tank wells. Do we need to go get all these wells approved? Because you're not gonna find it, if they're not on the water board thing, I don't think some of these wells that we're all talking about that are just cattle wells or some are home wells, but they're not water board approved wells, you have no way of knowing that, am I correct?
We typically check the OWRB website for things, so that would be a good comment. That would be a good comment to make. I think that, yes, I mean, if there are water wells in the vicinity.
I'm a neighbor that has water wells that are not permitted. Right, that's a technical argument.
That is.
Well, just my home water well is not.
Ponds and streams, it's not just the wells.
So
that's what I'm saying.
Let me-
He's saying they're only looking at what they have the ability to look at.
So you gotta give them, anybody that's got a well needs to have it, when we give them to the technical, you need to have a location of all it and submit, is what
See,
they're
he
telling
doesn't
them.
have, right, like my
And have the
cattle
water
well.
tested.
Right, I am clear on that, but they don't have any way to know where your home water well is if it's not on the water board's site or registered with the water board. Am I correct? So somewhere.
Yeah, we would need to have some record of that. If we rely on public records.
If we're having a
And the applicant
concern.
does, yeah.
Do you take springs into effect, water springs coming out of the ground?
Ponds.
Cattle drink out of them?
Surface water and off the top of my head, I'm not sure.
Wouldn't that be a concern? My cattle drink out of springs all around that place.
And that would be a fair comment to make. And let me take this opportunity to kind of circle back. When we first came in, some of the opening comments, I wanted to point out that this was a meeting to learn about the permitting process, and not to get into a lot of technical questions.
No,
And I appreciate it. I said we answer questions if we could, and I thank you for being here and being engaged, and I want you to feel like it was worth your time. But I do want to go back and check to make sure that, since we're saying, yeah, wait to respond to that or to provide that comment when the time is appropriate. But I want to make sure that everyone understands when that's going to happen and how you will know about it. The first thing is to make sure that you signed up on those sign-in sheets so that you have either an email address that we can read or a mailing address so you can be contacted. There is going to be a back and forth, most likely, with this permit application, in that DEQ is going to respond to the application after we complete the technical review and either ask for more information or ask for clarification. That will be called a notice of deficiencies letter. At that point, then the applicant has up to 180 days to respond to that. There may be more than one time that happens. There may be more than one back and forth. So this could take a long time. Ultimately then, if it progresses to a draft permit, that is when there will be notice. You'll get a notice. It'll be posted in the newspaper, and then if you're on that, if you provide information on that sheet, we'll contact you directly when the public comment period will start and when you can make these kinds of comments and how long it'll be open. It'll be open for at least 30 days. So I want to make sure that you guys understand that, and if you have questions about that, let's talk about that some more.
Will you be in charge of those meetings?
You'll probably see some of the same people here. We do have a gentleman at DEQ whose job is to facilitate these types of meetings, and he is out with some health issues right now, so he couldn't be here. So you have to deal with me. So apologize for that in advance. But I mean, it'll be some of the same technical folks. Hillary, as chief engineer, will likely be here, or not necessarily here, but if there's a public meeting, she'll participate in that process, and I'll be involved. And Jeff Biddick, as professional engineer, will likely be involved. So it'll be some of the same folks.
So you said the public meeting, if there is one, would be in Hennessey, or will it be somewhere else? It will be.
Well, yes, and yes.
Okay,
It would be
okay.
Hennessey.
We can help you find a better spot.
Yeah.
I mean, a larger area.
No.
Yeah.
It's a quick question, sorry. I was trying to follow along with all the questions about the low water wells and all that, the 20, 25 footers. When you do this permit application, do you work with Oklahoma Water Resources Board and figure out the water supplies, the aquifers, long-term effects, kind of like the Silkwood thing down the river here?
We rely on OWRB data, or the applicant would, to check for location of water wells. And it's the incumbent upon the applicant to provide any information that might be required for proximity to groundwater resources.
So you do take, I mean, you all work hand in hand when you go to look at these permits, right?
We don't work directly with the Oklahoma Water Resources Board now.
Would you introduce yourself?
Sorry, my name's Randy Poindexter,
And you are?
Kingfisher County Emergency Manager.
Thank you.
While we're elaborating a little bit on the water, can I just make a kind of a announcement to the audience? I tried to put together, I went to the OWRB site, I put together a map, a plat of all registered wells. I've sent out emails. I know I didn't get everybody in here. Some are a little bit new to the process. Text me if you have a well that's not registered. First off, get it registered with the OWRB. But if you would, send me, so I can put it on the plat, send to me, text it to me, just quarter section. I mean, you know, if it's hand dug, if it's drilled well, if you know the depth of it, or top of water even, that'd be great. You know, anything we can do with, on this part of it, I think would help, you know, help them, but it'll help the OWRB also when we go to them, right? I guess, I mean, so that's what I was trying to do. I know it's not a complete plat at all, but I'll be the point guy as far as putting it all together. But whoever's not on the site, whoever's not registered, you'll have to do that on your own. It's nothing to do. It's just a call, but the way I understand it, the way it worked for me. So thanks.
So
Thank you.
the engineering report done by Envirotech, I think the guy from Envirotech is down there. Does that not take into consideration the water wells and stuff in the area?
To your point, it has the ones that are mapped that we know about.
Only mapped. Your
Yeah.
home one that it's been there 100 years, that was hand dug, unless you take out a lot of water, it's probably not permitted. But how do we get our info to you before it goes that far? I guess that's what I'm asking. If it's my cattle tank well and it's shallow, but I could potentially have a problem that your 60-day, 30-day period, do I present that I have a well very close to this then? Where, I'm trying to figure out the technicality of how do you find out that, how do I just register it and, but if you've already looked and done your homework, then mine won't show up. How do you handle that?
I mean, I think the best way is when the public comment period opens.
That's the time.
Yeah.
Okay, thank you, I just wondered.
Mm-hmm.
So there will be another time that they can comment, correct?
Yeah, if the application makes it to the point that we issue a draft, what's called the draft permit, that's when the opportunity will be available to provide comment and or request a public meeting to discuss the permit.
Based on what you've heard tonight, what are our chances of getting that fixed?
No, I'm not a gambling man, so I'm not going to wager anything.
What steps, other than what you're talking about, would you take if it was across the road from your house?
Yeah, I'm not gonna talk about that. I mean, we just. You know, we look at the rules and regulations. We follow every permit. We follow the same process.
You know, we're pretty rural right here. But they don't have to go very far west where it's way more rural. Why they fix here?
Because they don't have.
Right.
Which is it's closer probably to where the money is. They're getting paid a hell of a lot of money.
If they're, yeah, listen, I appreciate you being here for the permit process. I appreciate the discussion. I want to thank you for being courteous to each other. You know, some of these meetings get a little rowdy. So you guys are a good bunch.
But thank you for being patient with us
Of course.
and understanding our concerns.
I understand it can be frustrating.
We thank you for listening to us. We really do.
Thank you.
You saying you'd rather leave a little blood on you?
And it's good to be plugged into what's going on around you and in your
Thank you all.
community.